All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Welcome. We are here for oral argument in case number CV18 0389, Dashi versus Nissan. Counsel, each side has 20 minutes for your argument this morning, and the appellant may reserve a portion of your time for rebuttal if you'd like. Just ask that you keep track of that yourself with the clock at the podium. The proceedings are being audio and video recorded, so if you would introduce yourself and your client at the outset, we would appreciate it. We have read the briefs and discussed the case, and if you would please keep that in mind, we would appreciate it. And with that, counsel, you may begin.
Good morning, Your Honor. Thank you. Brent Gelfie and my co-counsel Lynn Shumway on behalf of the plaintiff appellant and Tia Dashi. I know you're familiar with the briefs, so I'll be very quick about the background. A collision occurred. Our client's vehicle was struck in the side by a 2008 Nissan that did not contain two critical safety features: forward collision warning and automatic emergency braking. I can get into the details of those features if you'd like, but I think they're fairly self-explanatory. We believe we can prove that those features were both technologically and financially ready to be installed on a 2008 Nissan. We haven't had the opportunity to try to prove that because the lower court ruled that our case was preempted by federal an action of the regulatory agency, in this case NHTSA, that denied a petition for rulemaking with respect to whether it should enact rules with respect to forward collision warning and automatic emergency braking. We think that ruling by the lower court was wrong for 6 independent, separate, and compelling reasons that, particularly when taken together, compel a conclusion that this case is not preempted by federal law. And what I'd like to do very quickly is identify those 6 separate silos or 6 separate reasons, and then I'm happy to discuss those in order, or I'm happy then to take questions once we've maybe identified some of those issues a little bit more clearly. The first reason why we believe the case should not be preempted is there is simply no conflict. This is an implied preemption case. The question is whether there is an impossibility or a conflict in the performance of, in this case, Nissan's obligations with respect to the federal motor vehicle safety standards.
Counsel, let me ask you a question. Do these guidance documents from the federal government on automated cars, do they matter or do they not matter? The 2016, 17, and 18.
Yes. Well, and actually there's 13 guidance documents as well. They do not matter in terms of the critical pivotal question is this action preempted by the denial of petition for rulemaking? They do matter in this sense, Your Honor, in that they shed light and enlighten us on the question of what is NHTSA's intent with respect to technologies similar to this. And let me explain that. The 16 and 18 and 13 guidance documents relate to highly automated vehicles. There are 6 levels of automation. Level 0 are things like windshield wipers, turn signals, and guess what? Forward collision warning.
And I understand that.
Okay.
My question is just the first sentence of your opening brief cites and relies upon the 2006 guidance document, and then you get into more of it on pages 4 to 6. But then on reply, I got the sense that you were saying that is irrelevant, those documents to the issue here. And I wanted to know which is your position.
Our position is that preemption, the question of preemption, turns entirely on the denial of rulemaking in 2017. what the guidance documents do, and the reason why we cited them so prominently, is that even with respect to higher levels of automation, 3, 4, and 5, NHTSA is still saying the liability regime remains unchanged, and NHTSA has still not issued any kind of federalism preamble as required by Executive Order 1313-2. So it's clear that even with respect to higher levels of automation, NHTSA is saying there's no preemption. And the reason that's important and the reason why it sheds light on this is the primary reason Nissan, I believe, is going to say there should be preemption is because NHTSA desires innovation. Yes, they do. They desire innovation with respect to HAVs, levels 3, 4, and 5, not with respect to decades-old technology, forward collision warning and automatic emergency braking, which again
are you saying
levels.
that technology hasn't changed at all over time?
It does change.
You compared it to a windshield wiper. I mean, it seems to me there's a difference, and if there is a change in the technology and things are being improved, why isn't that significant, and why isn't that different than just a windshield wiper?
There is some change in the technology, Your Honor, and obviously it probably will continue to be improved as technology improves and goes forward, but a state court lawsuit and the traditional liability regimes that govern car makers, the regulatory framework for the FMVSSs and the tort law liability, don't change that. In fact, tort laws, Your Honor, are one way in which, one regulatory scheme. There's one way to hold automakers accountable for the decisions they make and how they implement technologies. So, for example, a seatback collapse. There's a regulation specifically on that, but the strength of the seatback is relatively minimal compared to what technology allows in seatbacks today. And so there are state court cases going on all over the country that say seatbacks shouldn't have collapsed. It met the minimum standard of the FMVSS, but there's still a regulatory function in the state tort law to say even if it met the minimum, it still may be defective.
Was there a statement saying that we're not going to regulate in that instance?
Well, actually, it's even more compelling in that instance, Your Honor, because there's specific regulation with respect to seatbelts, and that specific regulation doesn't foreclose out state court lawsuits that say even though you met that minimum standard, you can still be held liable. And here, and you just got me to one of the critical points here. The statute says here are the regulations. Here's a carve-out that says state cases can go forward. There's no preemption unless NHTSA has regulated that specific aspect of performance. And to regulate a specific aspect of performance, if you read the denial of the petition of rulemaking, they make very clear it requires specific findings, testing, and performance standards. In this case, how long before a collision is a warning, an audible or haptic or other warning given to the driver? How much brake support is given when the automatic emergency braking kicks in? Those are performance standards.
So let me ask you, counsel, why did NHTSA, is that what we're calling it? Why did they deny the petition for rulemaking?
Two reasons, Your Honor. One is they feared delay. They talked about that process of specific rulemaking and the time that it takes, and they say specifically in the petition that delay will cause additional. We don't want delay. We've been encouraging the installation of this technology since 1996. We want this technology in vehicles. If we embark on rulemaking, it'll take anywhere from 3 to 6 years or longer to get it installed. We want that to happen faster. And what they're saying with respect to innovation is we want that to happen because this technology, FCW and automatic emergency braking, is the technology that HAV technology depends on. And they say we want successively better versions of the technology.
Well,
so they do.
So they do want, it seems like, evolving standards, and doesn't that bring us? Doesn't that make this case? Isn't this case then very similar to Geyer?
No, Your Honor, I don't believe that it is, and I'll explain that. Yes, they want successively better versions of this technology. Nissan didn't put any version of this technology on the vehicle. In other words, In other words, Your Honor, there's no innovation here.
But let's say they'd put the earliest version. So they're going to be liable that if there's another version that came out 2 months later, they're stuck because they only have, it's changing every month. Which one are we going to hold them to?
We've got a lot of case law on that in Arizona, Your Honor. It's called state of the art. They can, if they have an affirmative defense to show that what they did was state of the art, then they're not liable for that. And that's mostly a fact-driven inquiry, but that's their ticket. And so,
let me that argument. I didn't see anywhere that you made this argument, and I want to know if this is an argument you're making, and if it isn't, why? Which is that yes, NHTSA articulated a substantial objective, but it did so in 2017. This was a car that was manufactured in 2008. That objective is prospective, not retrospective. You don't reach back in time and say, oh yeah, my objective 10 years ago was to do that, and so a regulatory objective in 2017 doesn't preclude a decision made in 2008. Are you making that argument, or and if you're not, why?
well, we do make the argument in the brief. I don't recall if it's in the reply or in the opening brief, Your Honor, that yes, the denial occurred in 2017. There's nothing in the denial that suggests it's retroactive, and of course, we do outline the regulatory history of this, Your Honor, which is beginning in 1996. NHTSA and its counterpart, the NTSB, were describing this technology, forward collision warning in particular, as technologically mature, and they have been encouraging the installation of this technology since that time.
Do you have a case for me anywhere in 50 states or federal that says what I just articulated, which is to use the words of Geyer, a substantial objective, Williamson, in 2017 is not an obstacle under obstacle preemption to a car constructed in 2008. Do you have any common law or any authority to that effect?
I don't, Your Honor, or we would have cited it. But the main answer to that question, I believe, Your Honor, is that a state court lawsuit encouraging installation of these technologies, which is exactly what NHTSA has been encouraging since the 90s, is in no way in conflict with NHTSA's with the denial of rulemaking here. In fact, those go hand in glove.
Weren't they encouraging the installation of airbags in Geyer? Was there some dispute that was not something that was being encouraged prior to the Geyer decision?
Here's the issue in Geyer, Your Honor, and there are several ways to distinguish Geyer, but the critical way is, in Geyer, NHTSA had set up a deliberate and well-thought-out regulatory scheme because they wanted to evaluate the effectiveness of two different types of restraint systems. And in fact, NHTSA spelled out the mix of the systems that they wanted because they wanted to be able to do some kind of econometric modeling of that to say which one is more effective. So Honda in that position was put into an impossible position. We complied. In our case, we used this kind of restraint system versus that, but both were what NHTSA had told us to do, and now we're subject to state court liability. That is, by definition, conflict preemption. There's nothing Honda could have done. Once it complied with that, if that state court case was allowed to go forward, it was in direct conflict with NHTSA's objective to get that mix.
Well, isn't that, we're talking implied preemption, right?
Yes.
And there are two kinds. And the first one is what? Impossibility.
Yes.
And the second is obstacle. It sounds much more like impossibility to me than obstacle.
I guess it depends on how you define that, Your Honor, but both in Geyer and in this case, there's no argument that technology was possible. It could have been placed on this vehicle. The argument is that somehow in this case, and I don't think there's a good argument, somehow in this case, a state court lawsuit alleging defective product liability for failure to install a safety feature thwarts NHTSA's objective to get that safety feature installed in as many vehicles as possible. State court lawsuits are working hand in glove with what NHTSA wants to have happen, and that's the whole point of state court lawsuits. And Geyer says it in the majority opinion. They make the point that state court lawsuits exist in order to provide additional safety protection to consumers and protect consumers from the consequences of manufacturer decisions. And that's the critical point.
Yet they found preemption.
They did because of the very specific facts of Geyer. And then if you look at the decisions that have been, we got Freightliner that was decided before Geyer was decided, which basically just animated all the things we've been talking about. In that case, it was failure to install anti-lock brakes. It said there's clearly no preemption here. Geyer comes along on very specific facts where NHTSA has made a very specific regulatory decision and outlined exactly what it wants to have happen. In fact, NHTSA argues this is what we wanted to have happen, and therefore there's conflict preemption here if the case against Honda is allowed to go forward.
In Geyer, the Solicitor General appeared in the courtroom, didn't he?
Yes.
And he said there's preemption.
Yes.
Okay.
Yes, sure.
We don't have that here.
No, we don't. And then you go forward to Williamson, where
Did
again
the Solicitor
now,
General appear in the state court proceedings underlying?
well, they can certainly make their feeling. NHTSA or the Department of Transportation, right, can make its feelings known through in the denial or through some other mechanism if they believe there's a federalism implication of their rule, or in this case, their denial of rulemaking. There's a mechanism. In fact, it's EO 1313.2 spells out that mechanism to say, here's what we've done to evaluate the preemptive effect of this. We've given people a chance to talk about it, and the decision we've made is there is preemption. None of these documents go through that process, and there's a little bit of a red herring in the defense brief, in the appellee's brief, that, well, you can't, there's no cause of action created by 1313.2. We're not saying that. We're saying the failure to follow 1313.2 is great evidence of NHTSA's intent in this case.
And then in Williamson, the Coast Guard said, no, we don't see any preemption.
That's Spritzma.
Spritzma.
But both Williamson and Spritzma said the same thing.
Do you have anything like that? I mean, have you asked the federal government to I don't know, for any opinion, anything formal on that, or are we just supposed to divine intent? And if we are, I guess we look to those automated guidance documents. Is that your argument?
Well, I think what you look to is the regulatory history, and you look at the denial of the petition for rulemaking, and when you read that and realize, well, wait, NHTSA wants installation of this as quickly as possible. We're denying it in part because rulemaking would delay installation, and we're in a state court lawsuit saying we want it installed. It should have been installed. Those go hand in glove.
But doesn't it also want improving technology, and is there a concern that we're going to lock in something if we mandate something right now, and that then there's no further technological improvements?
I don't believe that's the case, Your Honor, because if you look at the denial of rulemaking, they make the point about successively better versions of the technology. So they expect, and again, in the policy statements, they're talking about HAV technology being successively better that depends on this underlying technology that we say should have been put into this vehicle. And so, therefore, again, this is older technology. Will it continue to improve? Sure. Like almost all products continue to improve, and a lawsuit occurs at a state of time, right? But the defense has the option of arguing affirmatively this was state-of-the-art at the time we produced this product.
I guess I'm having trouble. What is the distinguishing point in 2 or 3 sentences from Geyer to here? They're both talking about a progression of innovation. In both instances, we have statement by inaction. What is the, if you just had to explain Reader's Digest, what distinguishes this case from Geyer?
The main point of distinction is Geyer involved an actual rule, Rule 208.
Is that it? Okay, so that's it.
Well, that's the main one, Your Honor, but and as part and parcel of that, the regulatory history was crystal clear about what NHTSA intended to do, and as I said earlier, as we talked about, there was an impossibility of performance or a direct conflict there that didn't allow, Honda had no out in that case. And then Geier then has been walked back, or at least limited to its facts, by Williamson and Spritzma.
Well, doesn't Sotomayor, in her concurrence, say, I think she says, inaction is not preemption.
That's right. And we go ahead, sorry.
But where inaction is motivated by some objective, it is significant for preemption purposes.
Right.
And so if that's the case, are we supposed to be compelled or persuaded by whether something's a rule or not, or whether the federal government has articulated a substantial objective or not?
We believe they have articulated a substantial objective, and that is get this technology in vehicles as quickly as possible. Our state court lawsuit encourages that. I'd like to reserve my last time for rebuttal.
Thank you, counsel.
May it please the court. I'm Tom Klein. Together with Brianna Campbell, we represent Nissan. What I would like to do is give you some concrete facts to provide a context for this discussion. And the concrete facts come to us from the NTSB. It's the agency that the plaintiffs often cite. They're known for investigating airplane crashes, for example. The National Highway Traffic Safety Administration, different agency under the Department of Transportation, is the one that's charged with ensuring the safety of automobiles on our nation's highways. But the NTSB published a report that is in IR 38, the index of the record 38. It was attached as Exhibit 4 to plaintiff's statement of facts in response to their motion for summary judgment. And it reports on a study done in 2013 by another independent organization, the Insurance Institute for Highway Safety, where they evaluated different types of automatic emergency braking. And basically the test was simple. Here's a car that's equipped with this technology. Here's a car that's stopped up in front of you. We're going to drive 25 miles per hour and see what happens. For a Subaru Legacy, the Subaru stopped, didn't hit the other car. For a Cadillac SRX, the Cadillac slowed down 19 miles per hour, hit the other car going 6 miles per hour. For a Volvo S60 that was equipped with collision warning system, it slowed down 14 miles an hour, hit the other car while it was still going 11 miles an hour. For the exact same vehicle, a Volvo S60 equipped with a different option package that they called the City Safety System, the vehicle only slowed down 2 miles an hour, hit the other vehicle going 23 miles per hour. For an Audi A4 and an Audi Q5, the system didn't even activate. It hit the other vehicle going 25 miles per hour. This is at internal page 26 of that document. NTSB then makes the obvious conclusion, automatic emergency braking capabilities vary significantly among passenger vehicle manufacturers and models.
So, counsel,
I'm saying in any of those instances, though, would you agree that they helped to a certain degree, they just didn't help as much in some situations as in others?
It's all over the map. Like for the Audi, it didn't stop at all. But the point is, NHTSA says, this is in 2013 when this study's done. Our vehicle's made in 2008 at issue in this case. NHTSA's saying, we don't know what is the best technology. What we want to do is let the car makers be the marketplace and compete against each other and develop this technology and compete against each other and come up with what is the best technology. And there's an agreement among...
Saying each one of those car manufacturers was using a different technology. It wasn't dependent on the size of the vehicle. It was more a function of the difference in the technology.
Those cars are all roughly the same size and weight. You know, they're all in the range of about 4,000 to 5,000 pounds in terms of curb weight. So it is differences in the technology. If you dig into this, some technology uses LiDAR, some uses radar, some uses cameras. What's going on now is they're combining camera with radar because there's all sorts of obstacles, advantages and disadvantages to each one. One of them doesn't work very well in foggy weather. One of them doesn't work very well in heavy rain, for example. So they're trying to combine the technologies. The other thing that's happening is the computer software is evolving very quickly. It's made leaps and bounds advances, and we've seen it in our own computer systems. I mean, we forget that in 2009 was the first time we had a smartphone and we can get on the internet on a handheld device. Same thing has been going on with automotive technology.
So, Counsel, can you address the relevance of this? I guess now we're going to throw in a 2013, 16, 17, 18, and there's like a 2.0 and a 3.0. Is that relevant or not? We have this 0 to 5, and talk about that if you can. I don't know, modernity, how complicated we are, and just if you can address that.
Yes. So the short answer is all of those policies are important because they all shed a light on what the NHTSA is thinking in their policy. So if we step back and put it into context, to find preemption, you need basically three elements. You need a process, you need a clear statement, and you need a safety objective for that clear statement. You need the process to deal with Wyeth and the other cases that say we want to make sure the agency is not making an arbitrary decision. Here, NHTSA followed a process. They've had public hearings. They've reached out. They've published their notices in the Federal Register. All of that is covered in our briefing, and we've copied all that stuff in Appendix 2 to the brief. Second, they made a clear statement. States, stay away from this. We need to let the marketplace develop this technology, and then once it settles and we have technology that works
But that's
well.
it. This technology.
Yes.
Your colleague says that this technology does not include the technology at issue in this lawsuit.
Well, I believe that is settled because there's some confusion, maybe I'll say, in the documents, but that's settled in the 2018 guideline where it says these guidelines apply to all of this technology.
Do you have a cite to the record for that?
Yes, I do. Yes, I do.
Well, go ahead. I mean, I don't want to take your time.
No, that's okay.
I'll find it.
I will find it. Here it is. It is Appendix Volume 1 at page 193. It's also quoted in our amicus response brief at page 31. Quote, this document considers automation broadly, addressing all levels of automation. Okay. So they've removed any doubt now. Now, why are they doing that? At the extreme, there's a self-driving car, which they sometimes call an HAV, highly automated vehicle. And there's the building blocks that lead you to the self-driving car. One of the building blocks is a forward collision warning system. It's sensing what's in front of you. The next step from that is automatic emergency braking. It actually applies the brakes for you. All of these pieces eventually become a self-driving car. Now, NHTSA is saying we want to leave out any regulation for all of these building blocks because we want to let the marketplace allow them to develop, get to the optimum technology, and then we say, okay, this is it. You have to have a system that will meet these minimum performance requirements. And that's what NHTSA will do. They'll say, here are the tests that you have to meet. Your vehicle has to be able to pass all these tests. And we know you can because we've seen the technology out there that will do it. All right?
Let me ask you, if this lawsuit was brought in 2015, is there an obstacle preemption argument?
I think there still is. It's not as clear, but NHTSA is developing this idea starting in 2007. That's when they actually say, I have to explain, the NHTSA does what's called a new car assessment program. So they go out and randomly buy cars and they will test them.
2012, they put in the...
Right.
So that would be the obstacle, is that it's part of the new car assessment program.
Right. But they started that in 2007. They said, wow, there's all this talk about this technology. The 2007 document makes it clear it's not ready for prime time yet, which is of an interest to our vehicle involving a 2008 model year. But what we want to do is encourage the development of this. How are we going to do that? We're going to start rating it. We're going to start telling the public, hey, these systems are out there, and we're going to tell you how it's doing. And what we want to do then is encourage the public to say, kind of like that idea, that my car will stop. Maybe if I'm inattentive for whatever reason, the car will stop itself.
And what about my other, the argument, the retrospective versus prospective, meaning the words written here, ink,
Right.
Of NHTSA
Right.
in September of 2017, or I believe, maybe January. How do they inform or retrospectively or retroactively erect an obstacle like a time machine?
So, frankly, I think retroactivity is a red herring. The first question is there a conflict? And here, once plaintiffs filed their lawsuit, if a jury were to find for the plaintiffs, they would, let's just take negligence, for example, of necessity find that Nissan had a duty in 2008 to put some sort of forward collision warning or automatic emergency braking technology on its vehicles. And it wouldn't just be on the Rogue, because if Nissan could do it on the Rogue, they should do it on all their vehicles. And if Nissan can do it, it should be all car makers. So Arizona, by a jury, would be legislating that all vehicles had to have FCW or automatic emergency braking technology in 2008. That's exactly the scenario that the court went through in Geyer, page 881 of Geyer. And that's why they said requiring this of Honda is going to affect the whole industry, and it takes away the choice.
So Geyer had the same anomaly, the same. Okay, so it's Geyer that answers that question.
It's Geyer, and that's where you start and end. Is there a conflict? If there's a conflict, then it's preempted.
And there's a conflict in Spreitsma, or however we're pronouncing it. Is the difference that we're not talking about technology that's developing, we're talking about propeller guards, or how do you distinguish Spreitsma?
So if you use that formula, the three requirements, there has to be a process, there has to be a clear statement, and it has to have a safety objective. The problem in Spreitsma was there was no safety objective. The Coast Guard said, we don't know if prop guards would help or not, so we're not going to require them. They weren't saying, it's really important for safety that you not have prop guards. Same thing with Williamson, 3-point belts in the back seat. We used to say that child seats don't fit with a 3-point belt, but that's not true anymore. Child seat design has changed, so there's no safety advantage for that anymore. So it's not a safety issue anymore. Therefore, no preemption. So that's the difference.
But can't you make the argument there's no real argument that any of the ones that are currently in place are a detriment, and we certainly want to encourage every auto manufacturer to be putting in some type of early warning or braking system? Doesn't that get you kind of close to Spreitsma?
No, I don't think so, because NHTSA is encouraging the marketplace by reporting, doing their NCAP testing and saying, look at this vehicle. This has got some pretty good technology, and encouraging the marketplace, the way they describe it, marketplace poll, to say, hey, I want that technology on my vehicle. So now the other competitors need to start catching up and getting that technology there.
Well, wouldn't a jury verdict do the same?
No, because a jury verdict establishes a standard that says whatever the technology was in 2008, you had to have it in that vehicle, which of necessity diverts resources to deploying that technology among all of the fleet, every vehicle being made in 2008. Now, the way, and you can see it in the documents, the way new technology is always deployed is you start small first. So you start in your high-end vehicles. The first Nissan vehicle that had automatic emergency braking is the Infiniti FX. Infiniti being Nissan's luxury brand. Lower volume sales, work the bugs out there, and then you spread it throughout the fleet. Same thing happened 40 years ago when we first got power steering and power brakes. It started in the Cadillac, and then it went to the Chevrolet. Same thing is happening here. And NHTSA knows that's the way the process works, because NHTSA are experts in this area, and they are encouraging that, but they don't want to have a state say, you got to do what you had in 2008, drop the bar, focus all of your resources on getting that technology in every vehicle in 2008, and don't innovate and don't come up with an even better system. To quote NHTSA, that would stymie innovation. That's what they mean when they're talking about that.
So, counsel, you say in your brief that the 2008 policy is, quote, the strongest reiteration of NHTSA's preemptive intent yet, period, end quote, well, in clarifying its position. Is that your position?
The 2018 policy for sure makes it very clear, for example, what we talked about earlier, that the policies apply to all technologies. And like 2016, NHTSA cites Geyer. Why would they footnote Geyer if they didn't want to have preemption?
Right. But I just want to ask, in the 2017 document, it said, and I quote, "We strongly encourage states to allow DOT alone to regulate the safety and design and performance." And that was at, so that's the 2.0 document. That, you can do a word search of strongly or strong, encourage, in 2018, and it's gone. Is there any significance in that in 2017, NHTSA strongly encouraged states to allow DOT alone to regulate the safety design law, and in 2018, that sentence is gone? Is there any significance in that? And is that the strongest reiteration?
So the short answer would be no, because none of those guidelines have said this replaces and forget about the prior guidelines. They're building on each other. So the 2017 guideline document and what it said is still part of the whole picture of what NHTSA is saying, as is the 2016 document, as is the 2017 denial of the petition for rulemaking, as is the earlier documents back to 2007 when they said, here's how we're going to regulate this. We're going to do NCAP testing and publish it, and we want to encourage innovation and not drop the bar and say, you have to do it, whatever was available in 2008.
So what about the words tort policy? Okay, we have that occurring in sort of these gradations year after year. And your argument early on is, yeah, those words, it says states should operate in the area of tort policy. Look at the heading. The heading is liability insurance. Okay. But in 2018, on page 5, there is no heading liability insurance. It seems to be just the state should remain active on, quote, tort policy. I don't have page 5 in front of me. But what does that mean, tort policy, in that context?
Okay, so let me step back. Our argument is the preemption is very narrow. You cannot have a claim saying lack of technology, you should have the technology. What you can have are things that NHTSA spells out in 2016, and remember, that document's not supplanted by the 2018 policy. They spell it out exactly. They say states are responsible for determining liability rules for the self-driving vehicle. Let me give you a specific example. Let's say Uber starts putting self-driving vehicles into their fleet, okay? And there's a wreck and somebody's hurt. Who pays? The state should be determining that. Are they going to require Uber to buy liability insurance? Is Uber going to set up a dummy shell corporation that doesn't have any assets? How is the state going to avoid that? Or is the state going to require the manufacturer of that self-driving vehicle to provide the insurance? Or, and NHTSA says this specifically, are we going to require the passengers to buy their own insurance? And now you don't have to worry about underinsured motorist coverage anymore. You get to decide how much coverage you want to have before you get into the passenger seat of that Uber vehicle. Those are the kinds of things that they're saying the state should do. The other thing they can do is this. Remember the Audi in 2014 won't stop at all? There's no bar to a claim saying, hey, Audi, you had this technology in your vehicle and it didn't work very well and it caused a crash here. And therefore, there could be a lawsuit saying, Audi, you should have had the system like Subaru had. But what is preempted is the claim that you didn't have any technology, because that stymies innovation. Because of necessity, if you have that lawsuit and the plaintiffs win, now you've locked in some old version of technology. Whenever that vehicle was made, you have to find that all vehicles on the road should have had that level of technology based on the model year of that vehicle. And that, NHTSA says, is preempted. Don't do that. They've dropped the gate on the lack of technology. Now, will they lift it someday? Yes. They'll either do it by a regulation or they'll write a new policy guideline document that says the technology is now evolved. And now...
Sorry for interrupting.
Yep.
If they had installed something in the 2008 vehicle, are you suggesting that they had technology, you can bring a lawsuit saying you didn't do a good job with that technology?
Yeah, yes.
So how is that different than you chose to install something that wasn't state of the art as opposed to you chose not to install anything and there was something that was state of the art? That doesn't seem like very much of a difference.
Okay, the difference is stymieing innovation, all right? If you want to go out there, because there were literally a handful, I think Volvo and Mercedes in 2008, very, very, like 99.9% of the cars on the road in 2008 did not have automatic emergency braking. Volvo did, Mercedes did. The plaintiffs could bring a claim saying, hey, Mercedes, your technology didn't work very well, okay? And Mercedes will be able to say it was state of the art, or they'll have all those kinds of defenses to them. But you can't sue Nissan or Ford or all the other car makers that didn't have that technology in their vehicles in 2008, because they're all working on it, and we want them to decide how they're going to deploy that technology, like in an Infinity, and then migrate it to the whole fleet. We don't want juries to be legislating and deciding on what the regulation should be, and a jury deciding, oh, you know, the plaintiff said that there's this NHTSA article from 1996 that makes it sound like the technology is all ready to go. It's clearly not. There's wide variations that are noted in that NTSB report on how the technology works. It's not ready for prime time yet in 2008. We want to encourage innovation. So I think I've described why there is a conflict. Let me just, in 8 seconds, say, look, the policy ought to be, let's avoid this risk. And here the risk was negligence of the driver.
Thank you very much, counsel.
Just a few points, Your Honor. To the last point that you raised, Your Honor, nothing stymies innovation like not doing anything at all. That's what they're saying. Somehow we just had legislation from the podium that, well, failure to install is preempted, but claims about the performance of these technologies are not preempted. Where does it say that? It doesn't say that anywhere, Your Honor. And the last point that Mr. Klein made, we don't want juries legislating. This is from Geyer. The Savings Clause reflects a congressional determination that occasional non-uniformity, small price to pay for a system in which juries create and enforce safety standards while simultaneously providing compensation to victims. Now back to the policy statement, Your Honor.
That's express preemption, though, right? The savings clause.
Geyer, no, that was in Geyer, but the savings clause.
Geyer's tackled express first.
Yes, but the ruling was on implied, impossibility.
Right. So the discussion about savings, is that an express or implied?
Well, the discussion of savings is both. The savings clause is saying all of this is saved except for these either expressly preempted or impliedly preempted. So I think that comment applies to any kind of preemption, Your Honor. But you raised the point about the policy statements and replete throughout the 16 and 18 policy statements are statements about states allocating liability to manufacturers. They say that states need to decide on that the liability regime remains unchanged. Those are non-preemption express statements by NHTSA, and there's no express preemption statement about any of these technologies. And again, if NHTSA perceived that there was either express or implied preemption going on here, it was obligated by 1313.2 to at least have a preamble, a federalism preamble that explained why they believed preemption was appropriate. They knew how to do it because they did it in 2015 for their new car assessment program for forward collision warning. They didn't do it in any of the other policy statements, and certainly not in the denial of rulemaking. Thank you.
Thank you, counsel, and thank you both for your excellent arguments. We will get something out in due course, and with that, we're adjourned.